A driver makes a single careless error on a crowded city street, loses control of their vehicle, and crashes into a bridge support. The physical impact of the crash shears a major utility pole, bringing heavy electrical power lines crashing down to the pavement. This single act of negligence ripples outward, creating 3 distinct victims. Claimant 1 is a nearby factory owner. The severed cable cuts their power, bringing production to a halt and causing a massive financial loss. Claimant 2 is a pedestrian. They successfully dive out of the path of the crashing car and avoid physical injury, but develop severe post-traumatic stress disorder from the near miss. Claimant 3 is a close friend of the driver. They witness the aftermath of the crash live on a local television news broadcast and suffer a severe psychiatric breakdown. The driver breached their standard of care. That breach factually caused the damage suffered by all 3 claimants. But under UK tort law, they will not all recover damages. The law of negligence does not rely entirely on factual cause and effect. It uses strict policy gateways to determine exactly who is legally owed a duty of care, leaving those outside the perimeter with no legal remedy at all. To understand damages, we divide harm into 2 categories. First is consequential loss, financial or psychiatric harm flowing directly from physical injury or property damage. Contrast this with pure loss, financial or psychiatric harm occurring without any physical impact on the claimant whatsoever. When a claimant suffers consequential loss, the courts apply the standard rules established in Donoghue v. Stevenson and Caparo v. Dickman. The duty of care flows naturally from the physical damage. When a claimant suffers pure loss, the rules change. These are classified as limited duty situations. The baseline legal assumption is that no duty of care is owed. The courts apply this restriction because of the Floodgates principle. If the law allowed general recovery for pure economic loss and pure psychiatric harm, a single negligent error, like severing a power line, would expose a defendant to boundless liability, compensating an indeterminate number of claimants for limitless amounts. Physical damage provides a natural boundary to liability. Without it, legal proximity is severed, requiring the courts to build rigid exceptions to keep the floodgates of litigation firmly shut. We begin with pure economic loss. The general rule is strict. A defendant does not owe a duty of care to avoid causing pure economic loss. We can see this mechanic in action in the case of Spartan Steel and Alloys Limited versus Martin & Co. The issue before the court was whether a factory could recover lost profits after a third party's power cable was negligently severed by the defendant's drilling equipment. The rule relies entirely on property ownership. Financial loss following damage to the claimant's own property is consequential and recoverable. Loss following damage to a third party's property is pure economic loss. Applying this to the facts, the factory did not own the severed electrical cable. It belonged to the utility supplier. Because of this, the lost profits from 4 future melts that could not be processed during the power cut were classified as pure economic loss. The court's conclusion was definitive. The factory's claim for those future lost profits failed. No duty of care was owed to them regarding that specific economic damage. Pay close attention here. Do not confuse consequential economic loss, like a pedestrian claiming lost wages because of a broken leg, with pure economic loss. Applying limited duty rules to standard consequential loss is a frequent point of failure in exams. In claims involving damaged infrastructure, the claimant's legal ownership of the physical property dictates the outcome. It is the necessary deed rate to recovering financial damages. There is a major exception to the pure economic loss rule: negligent statements. This exception originates in the landmark case Hedley-Byrne v. Heller. Hedley-Byrne established that liability for a negligent statement causing pure economic loss can exist if there is a special relationship between the parties. This requires an assumption of responsibility by the defendant and reasonable reliance by the claimant. The House of Lords later expanded this in Caparo v. Dickman into a 4-stage test to identify that responsibility. The defendant must know the purpose for which the advice was required. They must know it would be communicated to the claimant. They must know the claimant was likely to act on it without independent inquiry, and the advice must be acted on to the claimant's detriment. When these criteria are met, a duty is established. To protect themselves, professional advisors frequently attempt to escape this liability by inserting disclaimers or exclusion clauses into their contracts.
These clauses are strictly controlled by statute, depending on the nature of the parties involved.
Under Section 2, Subsection 2, and Section 11 of the Unfair Contract Terms Act 1977, business-to-business exclusions are only valid if they satisfy the requirement of reasonableness. For trader-to-consumer contracts, Section 62 of the Consumer Rights Act 2015 applies. Exclusions here must satisfy a test of fairness and good faith. In Smith v. Eric S. Glesh, the House of Lords struck down a surveyor's disclaimer precisely because it failed to meet these statutory standards. A professional's words can create a highly costly legal duty. Statutory law ensures they cannot simply write away that responsibility, particularly where a significant imbalance of power exists. We now turn to the second category of pure loss, pure psychiatric harm. This is defined strictly as psychiatric damage suffered without any physical impact or injury to the claimant. The courts mandate a strict medical threshold before a claim can even be considered. The harm must be a medically recognized psychiatric illness, such as PTSD, or a shock-induced physical condition like a heart attack. This boundary is inflexible. Mere grief, normal anxiety, distress, or worry do not meet the legal definition and are never actionable in tort law. Take note of a recent, highly testable legal update from the Supreme Court. In 2024, the case of Paul v. Royal Wolverhampton NHS Trust explicitly removed the long-standing requirement that the medically recognized psychiatric illness had to be caused by a sudden shock. Pure psychiatric harm is evaluated as a clinical diagnosis, not a subjective emotional state. This ensures courts only compensate scientifically verifiable trauma. Once the medical threshold is met, the law divides claimants into two rigid categories: primary victims and secondary victims. The rules for establishing a duty of care differ completely depending on which path the claimant falls into. We define the primary victim by looking at the issue in Page v. Smith. Is a duty of care owed to a crash victim who suffers no physical injury but develops a psychiatric illness? The rule dictates that primary victims are individuals who were in the actual area of danger or who reasonably believed they were in physical danger. In Page v. Smith, the House of Lords concluded that because physical injury to the claimant was foreseeable, a duty of care was automatically owed for the pure psychiatric harm they actually suffered. We see this early logic in Donoghue v. White, where a pregnant barmaid recovered damages after a horse-drawn van crashed into her pub, causing severe shock because she reasonably feared for her own safety. Secondary victims are entirely different. They are not involved in the incident and are never in physical danger. They merely witness injury to someone else or fear for the safety of another person. The legal barrier for secondary victims was defined by the Hillsborough Stadium disaster in Alcock v. Chief Constable of South Yorkshire Police. To prevent the floodgates from opening to thousands of grieving relatives, the court in Alcock instituted strict control mechanisms. A secondary victim must prove close ties of love and affection to the immediate victim, proximity in time and space to the accident, and they must perceive the event through their own unaided senses. The law relies on physical geography and relational proximity to restrict liability. It heavily favors the claimant directly in the path of danger, while strictly limiting claims from those who merely observe it. We can now resolve the legal tension in our opening scenario: the driver who crashed into the bridge support. Claimant 1, the factory owner, fails. Based on Spartan steel, the severed power cable belonged to a third party. The factory suffered pure economic loss, meaning no duty of care is owed. Claimant 2, the dodging pedestrian, succeeds. Applying Page v. Smith, they are a primary victim. They were in the actual zone of danger. Because physical harm was foreseeable, the driver owes a duty of care for their resulting PTSD. Claimant 3, the friend watching on television, fails. Applying the strict control mechanisms from Alcock, watching a disaster on a television broadcast fails the requirement of perceiving the event through their own unaided senses. The law of negligence operates as an exercise in judicial policy, not a direct measure of moral fault. Mastering tort law requires accepting that in cases of pure loss, courts intentionally draw harsh, arbitrary lines to contain liability. These boundaries ensure that a single careless act does not result in the economic paralysis of endless litigation.